Kentucky's public universities routinely violate open records law, which guarantees the access and open examination of public records, a Herald-Leader analysis has found. I'm Monica Cass, the higher education reporter for the Lexington Herald-Leader. Let's talk about what this means. The Kentucky Open Records and Open Meetings Acts protect the right of citizens to be informed of what decisions public institutions make, like state and local governments and public schools or universities. Meeting agendas, emails, staff memos, budget reports, or contracts with the university are all open records and can be inspected by the public. An institution can be found to have violated Kentucky's open records law for reasons ranging from not responding to the request in a timely manner, not properly explaining the reason it didn't provide responsive records, or simply for not releasing the responsive documents. When a public institution, such as a university, denies a records request, an appeal to the Attorney General can be filed to see if the institution is in compliance with the law. Over several months, we examined years of appeals filed with the Kentucky Attorney General's office, reviewing 156 appeals filed from 2012 to 2024. We looked at appeals filed relating to the state's 8 public universities and the Kentucky Community and Technical College system. In total, Kentucky's public higher education institutions were found to have violated the law on appeal around 65% of the time. The University of Louisville and University of Kentucky, the Commonwealth's largest universities, have the most appeals filed related to records. They violated or partially violated open records law slightly more than average when compared to the rest of the state's universities. Together, those two schools account for 111 of the 156 appeals filed. 68% of the appeals were found to have at least partially violated the law. Other universities violate the law at higher rates. Kentucky State University, for example, was found to have violated the law in all 6 of the appeals filed since 2012, and Northern Kentucky University violated the law in 80% of the appeals filed. The types of records requested varied. Some were personnel files of university employees, while others were records requested by journalists relating to specific incidents at universities. Appeals can be filed for a variety of reasons, from an institution not replying with the allotted time period to the requester disagreeing with the reason for the denial. Michael Abadi, a Kentucky lawyer with expertise in open records law, said access to open records is the driving force that keeps public agencies working for the people rather than their own private interests. Over the course of career, Abadi said universities have been some of the most frequent violators of Kentucky's Open Record Act. Even in cases where appeals are successful and a university has to turn over the requested records, litigation could go on for years, typically on the taxpayer's dime.